Breaking news and a big loss in court for Team Delulu. Hello, my friend. Perez Hilton here, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. Literally minutes ago, Judge Lyman in New York ruled on the Wayfarer Party's request to squash subpoenas, and they got a big win, not a unilateral win, because the goddess of gaslighting did score a narrow victory as well. I've got the judge's ruling, and let's go over it together. All right, Judge Lyman writes, Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Melissa Nathan, The Agency Group, and Jennifer Abel moved to squash subpoenas issued to cellular providers AT&T, Verizon, and T-Mobile by Blake Lively. For the reasons that follow, the motion is granted in part and denied in part. Lively served the subpoenas on or around February 12th. The subpoenas requested all documents concerning ingoing and outgoing calls or text messages related to telephone numbers belonging to certain Wayfarer parties and related individuals. Within the time period of December 1st, 2022 to the present, the hair care professional wanted all of this information for an over 2-year period. Judge Lyman continues, including but not limited to call logs, text logs, data logs, and cell site information. On February 14th, the Wayfarer parties moved to squash the subpoenas as overly broad and invasive. The court ordered the parties to meet and confer and to report back to the court whether any dispute remains by February 24th. It did. After the parties met and conferred, Lively agreed to remove the reference to all documents, remove the request for locational data, and clarify that the subpoenas seek only call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing text messages. Lively has prepared modified subpoenas reflecting these changes. However, by letter of February 24th, the Wayfarer parties reiterated their request to quash the subpoenas. The Wayfarer parties object to the fact that even as modified, the subpoenas continue to cover call and text logs revealing the phone numbers for anyone with whom the Wayfarer parties and other individuals communicated, regardless of whether such communication was related to the claims and defenses in this case. The Wayfarer parties therefore seek to have the subpoenas limited to communications between the subpoenaed phone numbers and other specific phone numbers of parties and witnesses that Lively would provide. Lively argues that the purpose of the subpoenas is to lead to admissible evidence regarding communications not only among the defendants, but among the larger network of individuals who perpetuated the untraceable campaign against Miss Lively, which justifies their broad scope. Lively also argues that the Wayfarer parties lack standing to assert the privacy interest of non-parties, meaning those not directly being sued. So, the judge cites law, don't need to read all of the relevant court cases, and he rules as such, quote, the subpoenas of the Wayfarer parties' phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfarer parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legitimate privacy interests, even though Lively has narrowed her request to exclude the content of calls or messages The phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer parties spoke to and when. Lively has identified no means to segregate those numbers that may have some relevance to her case from those numbers that would have no relevance and would reveal sensitive personal information. Lively mainly argues that the subpoenas will help to identify the larger network of individuals who perpetuated a negative media campaign against her. But according to Lively's complaint, this negative campaign did not begin until approximately August 2024. The judge coming through with some very helpful reminders. It is therefore unclear how communications to and from Wayfarer parties in 2022 and 2023 would reveal individuals who participated in the campaign. More generally, Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfarer party's privacy interests. Lively's complaint already identifies many individuals who allegedly participated in a negative media campaign. Lively may make discovery requests tailored to those individuals. She is permitted to use the tools of discovery to identify the contact information or telephone numbers for those individuals. Even assuming additional individuals participated in the alleged campaign, the hope that discovery will turn up information on such participants does not justify the broad scope of the subpoenas. Boom. The subpoenas must be squashed to the extent they seek the phone records of the Wayfarer parties. This ruling is without prejudice to the Lively party's service of modified subpoenas more narrowly tailored to reveal relevant information. However, here's her win. The Wayfarer parties have not demonstrated standing to object to the subpoena requests seeking the phone records of non-parties. In a previous court ruling, quote, a party demonstrates standing to challenge a subpoena directed to a non-party by showing that he or she seeks to protect a personal privilege, right, or interest. So the judge is saying they didn't meet the bar. They could have handled that part of it all better. Therefore, the Wayfarer parties may assert a privacy interest in their own phone records, which they have, but they have not provided any basis for asserting an interest in the communications of non-parties. Therefore, the Wayfarer party's motion is denied as to the portions of the subpoenas which seek the phone records of non-parties, meaning she can subpoena the phone records for Gina Rodriguez, let's say, his former Jane the Virgin co-star. And on the flip side, when Justin Baldoni starts submitting subpoenas, he definitely can subpoena Taylor Swift, and should. So, like I said, I view this as a much bigger win for Justin Baldoni and a huge loss for the wife of Scarlett Johansson's ex-husband. How do you see this all? Let's discuss in the comments section, and as always, thank you for your support.